Okay.
My Lords, I am very pleased to be able to offer my strong support for this bill introduced by my noble friend Lady Young of Hornsey. In preparing for this debate, I looked back in Hansard at what I tried but failed to achieve 12 years ago during the passage of the Legal Aid Sentencing and Punishment of Offenders Act 2012, when I was unable to persuade the then coalition government to accept an amendment to make it easier for victims of corporate human rights and environmental abuse in developing countries to take legal action in the UK against UK-listed companies. It was already possible to take action in principle, but in practice out of the question because of financial and other obstacles. So I sincerely hope that my noble friend will have more success with her bill, which is much more comprehensive and coherent than anything I proposed then. The passage of 12 years since my lesser efforts has seen significant developments in the global consensus for the provisions in this bill for a due diligence duty, liability and accountability. And on top of that, His Majesty's government has also been a prominent and leading supporter at the United Nations of the guiding principles on business and human rights, sometimes referred to as the Ruggie Principles. So this bill really is a logical next step and should by rights be a no-brainer for the government to adopt. Sadly, although support for these measures has grown substantially across business sectors and resulted in equivalent legislation in a number of other jurisdictions, the kind of abuses the bill is designed to prevent have persisted. This bill is a perfect opportunity not just to provide for accountability and remedy after the fact, but to be proactive and preventative. And we should be doing all we can to prevent the kind of cases I was referring to back in 2012, such as the one against Trafigura on behalf of 30,000 residents of Côte d'Ivoire who were affected by the dumping of toxic waste, or the one against Monterrico Metals in Peru, where 28 people who objected to the mining company's development plans were detained and tortured. Other cases have involved asbestos miners in South Africa and campesinos in Colombia and Peru. The situations I'm most familiar with and which provide a very good and helpful illustration of what this bill could help to prevent are from my engagement with NGOs working on human and environmental rights in Colombia. Groups such as AB Colombia and the Corporate Justice Coalition have provided clear evidence of persistent abuses linked to UK companies in the extractive and other industries. These harms affect indigenous and local communities, workers and important ecosystems. Business activities such as Glencore's Cerrejón mine in Colombia can lead directly to widespread environmental destruction, with the consequent loss of people's ability to enjoy a clean, healthy and sustainable environment. In 2020, Cerrejón's activities were denounced by no fewer than 7 UN special rapporteurs, who were independent experts assisting the Human Rights Council. One of them said that the company's operations in what is Latin America's largest open-pit coal mine had an impact on the Wayuu indigenous people, Afro-Colombians and campesinos, and was one of the most disturbing situations he had ever witnessed as Special Rapporteur on Human Rights. For example, air pollution far exceeded WHO-defined limits, increasing the risk of cancer and DNA damage. His Majesty's government should take the opportunity provided by this bill to do something about the impact of this UK-listed company. In addition, in Colombia, community leaders and human rights and environmental defenders face immense risks when reporting human rights abuses. According to Global Witness, Colombia is the worst country in the world for killing these human rights defenders, with 60 killings in 2022. This bill could make a real difference, and it has the advantage of strong, widespread, multi-sector support. UK businesses such as John Lewis, Tesco, Sainsbury and Twining have called on the government to be ambitious in bringing forward urgent legislation to mandate the kind of due diligence described in the bill. And as my noble friend has said, businesses want clarity and a level playing field, and their support is echoed by investors such as Legal & General. Our own Joint Committee on Human Rights has recommended the measures before us, which crucially includes subsidiaries and the whole supply chain. And there's public support too. A YouGov poll showed 4 out of 5 adults in the UK backing a new law requiring this sort of proactive, preventative action by UK companies. The bill, as we've heard, would also align the UK with legal developments in other countries such as France and Germany, and show that when it comes to the UN guiding principles, the UK is willing to walk the walk as well as talk the talk. The bill is a logical extension to our innovative and world-leading failure to prevent model of the Bribery Act, and also builds on the groundbreaking Modern Slavery Act, which still excludes the public sector. My Lords, there is an overwhelming case for His Majesty's government to close the legislative gap which currently allows human rights abusing companies to evade liability. Lady Young's bill has done the heavy lifting for the government, and I hope the noble Lord the Minister will be able to tell the House that the government will now grasp this opportunity and give the bill its full and speedy support.
Yeah.